Good afternoon, everyone. This is Whitney O'Reilly for something like our monthly webinars. This one today is Guarding Your Legacy, What Celebrity Estate Disputes Can Teach Us. This is going to be really fun, so grab your cup of coffee or grab your lunch. And we're going to talk a little bit, like People magazine, about some celebrities, some celebrity deaths, and how they can affect our estate plans. I think it just turned 12, so we'll do a little bit of housekeeping while people come in. But just important to know, I think we've all been on one too many webinars. Remember, all participants are muted. If you do have a question, I'd be happy to review it. If it's something that I think would be great for the group, I will definitely talk about that question or the answer to it. If I think it's something specific, then I will certainly try to get back to you, but always feel free to email me as well. My contact information will be on this presentation. You could just type my name into Google and I will show up. Do remember that our webinars are recorded. I try to do a webinar every couple of months. So anytime you have a question related to the estate trust world that you want to know an answer to, one, you can look back on my page and look at past webinars to see if I've presented on that. That could share some information with you. But certainly you're welcome to reach out to me at any time as well. So let me tell you a little bit about myself. If you haven't joined me for another webinar before, my name is Whitney O'Reilly. I run our wealth preservation group here at Cohen Seglius. We are based here in Philadelphia, but we have offices all along the Northeast. So we practice in Pennsylvania, New Jersey, Delaware, DC, Maryland, Virginia, where am I forgetting? New York, and I think Florida. So they're all the areas that we practice in. Normally when I do these webinars, I'll tell you if we're going to talk about specific state laws. Remember, when it comes to anything estate or trust related, it is very state specific, but there is an overlay of federal laws, federal rules, and of course, federal taxes. So I'll try to explain that to you. Today, we're going to talk about a little bit more on the West Coast, which is not something that maybe many of these viewers are used to, but as we're moving into a more international community, I'm starting to see clients with assets outside of, let's say, the Northeast. We have assets in other states, like let's say all the way as far as California, or maybe even assets in another country. And so we need to understand, what do those states' rules mean, or what does that international rule mean? And so we're going to look at a little bit of different rules in different states. Just remember, depending on the state you live in, what you and I talk about here today may be the same, as in they may have the same rules, but they may not have the same rules. So again, I run our wealth department. What does that actually mean? That means that we do estate planning for our clients. An estate plan includes a last will and testament and/or revocable trust. And that's the document that says what happens with your things when you're not here anymore and who's in charge of it. We're going to talk about these documents through this presentation. It also normally includes a financial power of attorney. So somebody can make financial decisions for you if you're alive, but for whatever reason, you can't make those decisions. Then we've got a medical power of attorney. That's so somebody can help you make medical decisions if you can't make them for yourself. And there's often included a living will or advance directive, which says what you do or you don't want at the very end stage of your life and whether or not you're an organ donor. So that's sort of a comprehensive estate plan. When it comes to estate administration, there is the probate process. That's the formal court process of moving someone who's passed away assets to where they're supposed to go by whom they want to be in charge of it. The non-probate process could consist of things like beneficiary designations or even a trust administration. When we have a trust in place and someone passes away, how do we administer that trust? I also run our estate litigation department. So in all things that we probably talk about today, we've got a case that we're litigating in regards to it. So I've got a lot of wealth of information. Our whole group, our attorneys, our paralegals, our assistants have been doing this probably combined for 40 years. I've been practicing in this area for about 20 years. I also give national lectures and I give some guest lecture presentations at Villanova. I have to say go Birds at least once because what a great job. We're going to have the parade here in Philadelphia on Friday. So if you're anywhere close by, come check it out. Today you're going to see I'm at least in this Philadelphia office. Sometimes on my webinars, I'm in one of our other offices, maybe even at my home office. But here today, I'm in Philadelphia. So go Birds. So, without further ado, and now that everybody has hopped on, let's talk about some of these star-studded estates, right? What happens when there's a flawed or an inadequate estate plan, right? So, we're going to talk about Lisa Marie Presley. Her date of death was January 12th, 2023. And we're going to talk about Anne Heche. Her date of death was August 11th, 2022. O.J. Simpson, date of death April 10th, 2024. And James Earl Jones, date of death September 9th, 2024. So we're going to see we've got Lisa Marie Presley. We know she's Elvis's daughter, right? She was also a singer in her own right. We've got Anne Heche, who's a famous movie star. We've got O.J. Simpson, a famous football player and then commentator. And then we've got, of course, James Earl Jones. We all know Darth Vader's voice, including many other movie other parts. Okay, so first we're going to talk about Lisa Marie Presley, right? There she is in the middle photo. We've got her daughter, Riley, on the left of her, and on the right of her, we've got Priscilla, right? What happened here? She passed away from complications from bariatric surgery. I never thought she looked heavy set, but I guess you can have bariatric surgery even if you're not incredibly heavy set. But she passed away at the young age of 54. She had 4 children, but one had already passed away by the time she passed away. So the first pitfall we're going to talk about is execution requirements, right? Let's talk a little bit about family dynamics. She was the only child of Elvis Presley and Priscilla Presley. Priscilla does have a son from another relationship. When Elvis passed away, I can't believe he passed away in 1977, he left his entire estate to his daughter, right? The entire estate to his daughter, Lisa Marie, and it was in a trust that would pay out to her at the age of 25, which was in 1993. Let's pause there for a second because this is actually not what we were going to talk about as a pitfall, that it's an execution requirement. But here's a cause for concern for me right now, as in I've been practicing for 20 years. When we have someone pass away and assets go outright to a minor child, it often leads to bad results. And here, right here, is the beginning of the bad results, which is, why did someone draft for Elvis Presley, who had who knows how many millions at the time of his passing? I think maybe even 100 million rights to lots of things. Why did we have a trust terminate when this child turned 25, right? Why didn't we have a trust for a longer period of time? Or better yet, a trust for their whole lifetime? So something that's really important for all of you on this call, you might say, well, I don't have $100 million, so what does it matter? And the answer is, you all either have a minor child, a minor grandchild, a minor great-grandchild, and what happens if they inherit, whether they inherit $1 or $100 million? What happens if they inherit at too young of an age? Well, I can tell you right here, look what happened to Lisa Marie. That money went outright to her and she lost most of it thereafter. So the answer is that's what happens. Whether they're just not financially sophisticated at that time, they lack that financial maturity because they haven't invested millions of dollars before that. Maybe because they're dealing with a tragic situation of a parent or a grandparent passing away. Maybe it's just because they're easily taken advantage of because they're in those positions. But what I've found over the years of practicing is we really want to make sure that we're protecting these beneficiaries for a period of time, maybe even their whole lifetime. outside of just having sort of that minor protection of having someone else in place to help that minor beneficiary make good decisions with those funds until they reach a certain age, there is also the added benefit of having asset protection. So what I mean by that, that trust that was there for Lisa Marie, and I didn't read that trust, so the caveat is I don't know what it says. I'm guessing what it says though, that anything that went to Lisa Marie until she was the age of 25, if let's say she got married and divorced, the assets in her individual name would be subject to a divorce proceeding, but the assets held inside of this trust couldn't be accessed by a divorcing spouse or any creditor, depending on the wording of that trust. That's amazing, uber, super creditor protection. And as we know, or maybe you don't know, I'm going to tell you right now, Lisa Marie was married 4 times in her lifetime, and when she passed away, she was not married, right? So that protection might have been good for her for a longer period of time. So that's the first sort of extra. We've got these execution requirements, but on top of it, what I'm seeing in Elvis's estate is somebody should have a trust for Lisa Marie's whole lifetime. Maybe that would have changed the trajectory of her life and these assets. I mean, that big of a decision. So important number one for all of you listening is if you don't have a minor's trust underneath your estate plan, whether under your last will and testament or your revocable trust, you should go back to your estate attorney and make sure that you've got that. Second is make sure that age makes sense for a distribution, right? When it goes outright to the beneficiary. Normally, I say if a beneficiary is receiving 5 million or more individually, then that trust should be for a longer period of time than, let's say, 30 or 35. I also don't like trusts ending before 30. Just like you see here at 25. We know I have a daughter in college right now at 18. At 25, I'm not so sure she's not still going to be in school, still being like a kid, probably not married or divorced yet. So she could have those protections longer. So we like that age to be a little bit longer. But okay, so that's the first recommendation. Make sure that you have a minor's trust and make sure the length of time of that trust is long enough. Obviously, we see what happens here if it goes out too early, right? But Lisa Marie did a good job. When she was 25, she got really good advice that said, okay, well, all this money's come out right to you. I think I need an estate plan, right? Everybody needs an estate plan. You're going to see that in the next case with Ian Heche. But it's really important to get a plan in place. And you might say, I don't have a lot of money, or I don't care what happens with my things. But the answer is you do care what happens with your things. You do want them to be as protected as humanly possible. You do want to pay as little tax as humanly possible. You want as much to go to your family members as humanly possible, your loved ones, your friends. And then second, even if you don't have a lot, you still want the people that you want in charge, and you want the people that you want to inherit to be the people that you want to inherit, even if it's just written on a piece of paper. So it's very important to have that plan in place. So she did get a plan in place. She got a revocable trust. It was called this Promenade Trust. She created it in 1993. She was the settler and the initial trustee. And at one time, we think the amounts in it were worth about $100 million plus ownership of Graceland, right? When she passed away, she had 4 children. One had already passed away from suicide at the age of 27. That happened in 2020, which is absolutely awful. And she also had Harper and Finley, who were twins. And those twins were aged, it was either 13 or 14. So as we're talking about minors, we talked about Elvis giving things to his minor children, but here we've got Lisa Marie doing the same thing, right? So, okay, this all sounds good so far, right? She did better than, let's say, her dad. She created this revocable trust that had sub-trusts for her family members inside of her estate plan. So why do we have any pitfall here? And let's move to the next part. Well, here's the pitfall. This sounds really easy, right? It's an execution requirement. How hard can it be to execute a will or revocable trust, right? We can print out a form online. We can do it through legalzoom.com. Actually, I don't even know if that's in existence anymore, but I'm sure there's some AI-generated estate plan package that you can facilitate through an online platform and print out. Well, the answer is, and I can tell you this from 20 years in practicing, administering thousands of estates and trusts, I actually have this happen with a great deal of frequency, as in people print out a plan or they get a plan and they don't execute it correctly, and then it doesn't work. Well, here we've got what happened to Lisa Marie. So we've got an invalid 2016 amendment. So she was allowed to amend her trust. What she attempted to do while she was alive is she tried to remove her mom and she tried to remove her business manager, who I think actually helped lead to the downfall of not having much money. I think he sort of squandered or made bad investments. Obviously, that's just the word that I've seen on google.com, but certainly seems like she was having a falling out with these individuals and she wanted to name different trustees of the trust. Well, what her mom said after she passed was, she never got a copy of the amendment, and since she was the acting trustee, she was required to get that. She also said there was problems with the dating and signing, including that Lisa Marie's signature did not look consistent on a previous amendment versus this amendment. Also, her third contention in regards to this 2016 amendment was that the amendment was not witnessed and not notarized. Okay, well, you might say, okay, well, what are the rules? So let's first take a step back and look at when we come to talk about trust, what happens here in the United States in regards to how trusts are managed? How are they created, administered, or terminated? And so each state, well, not all states, but we've got this thing called the Uniform Trust Code. It's a model law here in the United States. It's not binding, it's influential to the states. And many states, 36 right now, have enacted some version of this Uniform Trust Code. So this is a place to look to for guidance. It may or may not have legal authority. So here I'm just showing you a few of the states. Pennsylvania, because I'm here in Philadelphia right now, Pennsylvania has the Uniform Trust Act. They have their version of the Uniform Trust Code, and that's codified in the Pennsylvania's Estate and Fiduciaries Code. That's also known as the PEF Code, and that's in Chapter 77. Obviously, the same has happened for the New Jersey Uniform Trust Code. They've enacted a version of the Uniform Trust Code. That's Chapter 31. Pause for a second. What Pennsylvania has enacted and New Jersey has enacted is not the same thing, right? The Uniform Trust Code is that influential, not binding model law, but each state has sort of picked what they wanted from the Uniform Trust Code and enacted their own, right? So we've got to look at the state level to see what's going on with trust. New York, because we're close to New York, is the EPT, Article 7. And because we're going to talk about California, right now, Lisa Marie Presley passed away in California, so we're dealing with California law. California has a probate code, and that's Division 9, right? So we're going to look to that for advice. So now we're going to talk about California, right? What does California say is a valid amendment? But then also, what is best practice? Because I have clients ask me this all the time. Is this actually required? Do I have to have two witnesses and a notary for this particular document? And my answer is, here in Pennsylvania, let's use Pennsylvania because that's where I am right now. Not all the documents in your estate plan have the same execution requirements. They're different. The will is a little different than the financial power of attorney, which is a little different than the medical power of attorney and living will. Oh gosh, well, what do we do about that? Well, my answer is best practice. All documents should be signed in front of two witnesses and a notary. There are a couple of states here in the United States that require three witnesses, and that's not the only thing, right, at play. It matters where you sign, how you date it. But again, best practice, maybe it's overkill, but maybe we want it to be overkill because if we have different execution requirements and different packages going out in different ways, that's when some of these kind of things happen where some mishap happens. So California has a rule. It's exclusive or not. There's actually been a lot of court cases on the West Coast in regards to this. So what this explains is the probate code in section 15402 states that unless the trust instrument provides otherwise, the settler may modify the trust by the procedures for revocation. So the problem therein lies in the trust might say how the document can be amended, right? Modified. If it doesn't say, we've got this law that we just talked about on the last slide. But what if it doesn't say anything else? Can it be both ways? Can it be what the state law default is and what it says in the trust? Or is it what is in the trust only? So here's another piece of advice for everyone. If you have a revocable or irrevocable trust, we want to make sure that that document says how the document can be modified and whether or not it's exclusive of the state law default or not, right? In this case, it wasn't. So there were some questions in regards to that. First, if the trust instrument explicitly makes that method exclusive, then the trust may be revoked only in that matter. So we know if we've said exclusive in the document, it's only that way. If it's not exclusive, then we can have the statutory interpretation as well. And it's writing other than a will signed by the settlor or any other person holding that power of revocation delivered to the trustee during the lifetime of the settlor or the person holding the power of revocation. Well, we know by what Priscilla had said is she never got a copy of the trust, right? So it was an invalid amendment. But what ended up happening here for Lisa Marie is what often happens in large cases or when we have disagreements is some form of mediation, negotiation, or let's say a court case that's going to solve the problem. And so right here, we've got a family settlement agreement. And basically that family settlement agreement said that Riley, her daughter, her oldest daughter, so the one with bangs in this picture, her oldest daughter would get to be the successor trustee. She had wanted in that amendment, she wanted to remove her mom Priscilla and her business manager and replace them with her son and her daughter, Riley and Benjamin. Now remember, Benjamin had already passed away, so even if that amendment was valid, he would not be acting because he had passed away by suicide in 2020, right? So basically, the settlement said that Riley would become the sole trustee. Priscilla got an undisclosed amount of money. Why do I feel like it was like $1 million? She got some payout, and she was able to be the trustee of a subtrust under that revocable trust for her other son. He was getting 1/9 of the estate. So the next question is, okay, all the parties agree to that. Everybody signed off on it, but is it required to get court approval? And the answer is, I don't know, right? There was some argument whether or not there needed to be court approval or not. As an attorney who's been doing this for a long time, I talk to executors and trustees when we're administering the estate. I tell them that they have a fiduciary liability. We're going to talk about that later when we get to O.J. Simpson's estate, which is when you're acting as the executor or trustee, you have a fiduciary liability. You have to do certain things in the estate and trust for the benefit of those beneficiaries. And the only way that you can get 100% absolved of that is have a court sign off that you did everything correct until the end of that estate or that trust, and the judge approves what's happening thereafter. Well, that costs a lot of money and it takes a lot of time. So in many states, we have the ability to settle things outside of the court's purview, right? By agreement by all the parties. Again, it depends on the state. Some states allow it with a lot of flexibility, like Pennsylvania and New Jersey. Some states don't allow it with a lot of flexibility, like states like Delaware or California. So again, it depends the state that you are in. Again, best protection possible would be going through the court system. But again, that takes a lot of time and a lot of money. And when we have a very straightforward estate administration, let's say not $100 million, let's say it's your estate. Your estate with your house, your life insurance, your bank accounts is worth a couple $1,000,000. You and your spouse pass away. Hopefully not in a plane crash like we had in DC, but let's just say it was a plane crash, right? And it's all going to your children. We probably wouldn't want to get court approval. Although if your children are minors, we might actually be required to get court approval. So again, it depends on the situation, but we might be able to administer that estate informally, which makes things easier and less expensive, right? So here's this picture of Lisa Marie, her mom Priscilla, her daughter Riley, and then her twins on either side. There are minor trusts in place for her children. So she did one better than Elvis for a longer period of time. I'm not so sure Priscilla's motivations. again, I couldn't quite figure out who's in the wrong here, who's in the right. But we do know that Lisa Marie wanted her daughter Riley to act. And in the end, that happened, which I think is really important. It's really important for me when I administer estates or create estate plans for individual or anyone in our group. We want to make sure that your intentions are followed through with, right? When I pass away, I don't care if you think what I'm doing with my assets is what I should be doing, but I want to make sure that my wishes are adhered to. So when I see in the end, what Lisa Marie wanted was that she wanted her daughter to act as the trustee. She didn't want it to be this business manager, Priscilla. That gives me some satisfaction in knowing that maybe the world righted itself a little bit. And I do understand Priscilla wanting to be the trustee of a subtrust for her son, because having a sister's child, much younger in age, manage a trust for an uncle is probably not something I would recommend drafting, right? I normally don't even like siblings to be trustees. I don't really like to mix those roles, but sometimes that's all the people that we have, right? So that first pitfall is execution requirements. One, you want to make sure if you have an estate plan, it was executed correctly. We talked about how to do that under California law, but it depends what state you're living in, what the rule is. Remember, best practice could be more than that, right? For here in Pennsylvania, we don't need two witnesses and a notary for all of those documents, but we put it on each and every single document as a best practice. There's lots of reasons otherwise to do that, even if it's not required by law. One, because if we're executing all the documents at the same time, it's easier to have the same requirements. It's also really important. These documents are giving away your rights during your lifetime without getting court approval. I want witnesses to be involved. I want a notary there and available, right? To make sure that Lisa Marie wasn't out of her mind, right? To make sure that she knew what she was doing, to make sure it was really her making these changes, right? We didn't really talk about that second one, which was her signature, right? But I've had many litigation cases where we're not sure if the signature on the document was the signature of that person. I feel like that's going to get harder over time as we virtually are able to sign things. That would be expert testimony in a court case. That would be up to a judge to decide on whether or not that signature was really that person's, with maybe witness testimony or evidentiary support of other writings. To me, I thought the signatures looked very similar. I think it was Lisa Marie's signature. I think Lisa Marie was trying to do this. I think she just didn't give a copy to her mom because her mom and her would have had a beef about it. And she didn't realize that that was a requirement of that revocable trust, right? So we know that the pitfall is one, make sure that your documents are executed correctly. I will stop here for another second and say, we're going to talk about this a little bit more with Anne Heche, but there are some states here in the United States that have now signed electronic will statutes. So right now, best practice still for me, all along the Northeast where I practice is we have paper, hard copies of your estate plan, wet ink signatures, which sounds like something from a long time ago because we can e-sign so many things now. But the answer in many of the states along the Northeast do not have the ability to sign off on these documents, all of them or just most of them. So a lot of states have something very specific for a will, but not any of these other documents. So again, it might help a little if we can do something electronically, but if it's not for the whole estate plan, I'm not so sure that that's that helpful for me. So again, I think rules are ever changing. If we go back and look at this webinar, I'd say in 10 years, I think people will say, well, what do you mean a wet ink signature? I think we're going to be able to do estate plans in some virtual capacity. And we're already starting to do them in some virtual capacity where we can do a signing appointment virtually and send documents to a client to execute in front of witnesses and a notary and send back, right? We can have those initial calls either virtually or by conference call. But that is something that is changing. And that sort of brings me to our next famous individual who passed away, which is Anne Heche. Okay, and I'm going to actually look. If anyone has any questions, certainly let me know, although I can't seem to see that on my screen right now. Oh, yes, I can. There we go. Sometimes I need my children to help show me when we've got these webinars where each button is, and when my, the video vanishes or the slideshows vanishes, how to do it. But of course, today I'm here in the office, so I'd have IT help me. But hopefully that gave you some really good information. One, about basic execution requirements, what to do with minors, right? And how to make updates. I guess I didn't say, but it's really important to understand that the laws are ever changing and your life circumstances are ever changing. So once in a while, you do need to go back and visit these documents. I know it's hard to come and see an attorney and talk about death. No one wants to pay us, and nobody wants to think about passing away or becoming incapacitated. But it is really important. It's really important for you, and it's really important for your family members. So I normally say every 5 to 7 years, check back in unless some major life event has happened or you read about something very important in the news. Remember, I'll give this plug right now. We've got the federal estate tax sunsetting at the end of this year, 2025. So that's a big one. So it might be on all of your radar to reach out to your attorney to say, what, if anything, should I do? Remember, when somebody passes away, there are state level death taxes involved or probate fees, and there are also federal level death taxes. The federal level death tax is a 40% tax, so it's a pretty gnarly one, but there's a large exemption right now. It's 13.9199 for 2025. But 2026, it's supposed to sunset back to 5 million. Now, the people listening to this may say this is fantastic to watch something about $100 million, but I don't have $100 million. But you'd be surprised that you could have 5 million if you each have a $1 million life insurance policy, a house, and a couple bank accounts or investment accounts. Maybe you're getting close to that $5 million number, and you're not a famous individual. You're not someone wildly wealthy. So this is really important planning for all of us, right? Now we get to Heche. She is a famous movie star, although I think she got her start in a soap opera. But pitfall number two, this is awful and happens on a constant basis. I understand it because I know a lot of people said, how can someone not have a will or trust? Again, as I just mentioned, nobody wants to pay us attorneys, so we're really expensive, and nobody wants to think about dying or incapacity, and then we're all busy. My husband and I own a business on the side of being an attorney. I have a lot of things to do in the morning, in the afternoon, and at night, and on weekends, right? I have a family as well. So it's really hard to also find that time. But I have a lot of estates even today, out of the hundreds that I'm administering each and every year. Probably a quarter of them are with no valid last will and testament or revocable trust. And that breaks my heart a little bit, because what I was saying in the beginning is I really want to make sure that we're fulfilling the intentions of someone who passed away. I'm smiling a lot and I'm talking sweetly, but these are really sad things. These are people that have passed away, and we really want to make sure that their wishes, their legacy, their hopes and dreams, the things that they wanted to have happen to their or go to their family members or their friends, is actually facilitated. So we want to make sure that that happens. And one way to do that is to have a last will and testament. Well, Heche, she didn't have a valid last will and testament. And remember, she passed away in a fiery car crash. How old was she? I think she was 50. She was in her 50s, 53, I think. And she left a minor child. So we've got this kind of floating through here that we've got minors involved a lot of times when people pass away. Even if you say, my daughter's in college now, right? She's not a minor anymore. One, be careful with that answer. My daughter's 18. She's not a minor for some things, but here under Pennsylvania, under my will, if I state she is a minor till the age of 25, she is still only a minor, right? So at 18, she might be the age of majority for some things, but not everything, right? There's an age to buy a gun. There's an age to drink alcohol. There's an age to drive a car. And some of these things are state specific, and some of these things have a federal overlay, but that's really important to understand. Anyway, she had two children. Her one son, Homer, was 20, and her other son, Atlas, was 13. Oh, close in age, actually, to Lisa Marie's children. Oh, that's awful. Anyway, she didn't establish a will or a trust, so they had to file for probate. Here, when we don't have a last will and testament, it is called intestacy, right? An intestate estate. That means there is no testamentary vehicle that the assets are flowing through. So that means we're looking at the default law of the state that the person was domiciled in when they passed away. Sometimes even domicile can be tricky, especially for famous individuals that I represent. They might have homes all over the place and they might work all over the place. So that can be just an important component piece. If you have assets all over the place and you spend time all over the place, you'd want to figure out with your estate counsel what state we would be administering that state in, and maybe what state would be most beneficial for you, right? Here in Pennsylvania, we have a state level death tax called the inheritance tax. If, let's say, my husband and I never got married, we are just together. There's no common law marriage anymore here in Pennsylvania. If I pass away, my assets that transfer to him are subject to a 15% tax. If I go to Florida, 0% tax, right? So it also is really important to work with your team to make sure that you're paying the least amount of tax possible. So here we've got this probate versus non-probate. Let's talk about that for a minute because clients get very confused as to what probate means, what's non-probate, and then what's the overlay of tax. So first I can tell you, let's start here in Pennsylvania. In Pennsylvania, all assets you own are subject to Pennsylvania inheritance tax, except real property in other states and life insurance, all subject. So whether or not it's a probate asset, as in it passes through the coin-apported system, as in you own an individually held asset, the only way to touch it after you pass away is by having an executor sworn in, and they are able to touch the assets and move them where to go through that probate process, looking at that last will and testament, or through the non-probate process, which is things like a beneficiary designation, right? But even having that beneficiary designation makes it out of the probate process, but it is still fully taxable. So it's really important to understand that. And some states' probates are worse than others. So let's use Pennsylvania, since I'm here in Pennsylvania. Pennsylvania only charges a few $100s per million. So, and you can opt out of a lot of it as long as you have a carefully crafted estate plan. You can opt out of a lot of it. So Pennsylvania's probate process, not so bad. Maybe we want to avoid it, but maybe we don't need to. But in, let's say, California, probate is like a percentage of your estate that they charge. And if you go through the non-probate process, you don't owe that, not tax, but probate fee, which could be a very large number. So in California, it is way more common to have a thing called a revocable trust than, let's say, only a last will and testament. So again, it matters what state we're in, which documents we're going to have. But here, we've got a couple of issues in regards to this pitfall, right? First, we had pitfall 1, no execution requirements. We've got a little bit of information about minors. Now we have intestate, not having a will or trust at all. But does she really have a will? So when she passed away, she did have a writing. So does she have a valid will? And who is going to serve as her executor or administrator? So the executor is the person that is named in the last will and testament and is acting. An administrator is a court-appointed person who will be acting. And again, we have her ex, I think I'm saying husband, but I'm not sure if they were married. And that's this James Tepper. He was the one who petitioned the court and said, I don't like what's going on here. There is a valid last will and testament, so there does not need to be an administrator appointed. There is an executor who should be appointed through this will. It's myself and not an adult son, a son. Furthermore, this adult son was estranged from his mom, maybe has some substance abuse problems, and does not have the acuity to handle an estate with the complexities that this one does. So here we've got an email will. We just talked about the electronic will statute that is around in many states, not in California, at least not at that particular time. So let's look at this. She has sent this email to what looks like actually a number of individuals that says, FYI, in case I die tomorrow and anyone asks, my wishes are that my assets go to the control of James Tupper to be used to raise my children. One, that's my first concern is, what does that mean? Are we giving the assets to him, or are they going to his children? So I don't like that ambiguity right there. As an attorney, I would say there's some ambiguity, as in, do the assets go to him and he's supposed to help his kids with those? Or is it going to him like in a trust, and those assets are really for those minor beneficiaries? So it says it'll be divided equally among my children, Homer and Atlas. Remember, Homer comes from a previous relationship. Atlas is James Tupper's child. He's also famous too. I don't remember what he is in, but look up his name, maybe watch one of his shows. When the last child turns 25, everything has to be sold and goes out right to them. Here we see this darn 25 again. Bad, way too young for anyone to get things out right. That's my answer as an attorney. Could your specific case be different? And the answer is absolutely. Each person has a very individual plan. I sometimes get clients that ask, like, could I just have like a boilerplate estate plan? And the answer is there is no such thing. There are boilerplate provisions that should go in absolutely every document you have, but each situation, each estate plan is unique in and of itself. And then it says, if all my family, James Tupper, Atlas, Homer died together, my assets will go to Elliot, her nephew, to be divided among my nieces and nephews equally. Again, here's this ambiguity that says, wait a minute, does it go to Elliot and Elliot can give stuff to his other nieces and nephews, or is he supposed to hold it in a trust for his nieces and nephews, even though there's no trust construct in this email, right? So it might sound easy to say, I want everything I have to go to my children, but right here in something very simple, there's already some complexity that I wouldn't know what to do with, right? But it does look like it's naming James Tupper to act as the executor, and she wants her assets to go to her children. That last clause that I read to you, you guys should all have that in your revocable trust or your last will and testament. That's often called the takers of last resort clause. That says what happens if all the people previously named have passed away. And that's important to have. I don't administer takers of last resort every year. I'm trying to think of the last one that I did. It doesn't happen all the time, but it does happen from time to time. Let's use, we're talking about famous individuals. Let's talk about, the recent news. We had a plane coming into DC or past DC, I can't remember, that had whole families on that plane. If you were one of those individuals, where would you want your assets to go? So it's very important to put that in your plan so that if something tragic were to happen, we make sure the assets go where you want them to go, and hopefully in the most protected way, right? So now let's see, is this actually a valid last will and testament? So again, we have to look to the state law. Right now we're looking at California because Anne Heche passed away in California. I will also say I just went to a tax conference in Hawaii. There are two major tax conferences here in the United States for estate practitioners. One is called the Hawaii Tax Conference, and one is called Heckerling. One is in Hawaii, one is in Florida. So you know why I went to the one in Hawaii. No, I think the one in Hawaii, it's geared more towards the West Coast. The West Coast has more community property rules. The East Coast tends to not have community property rules. So it's really important for attorneys, especially if you have, let's say, assets all over the United States or all over the world, to really understand some of those differences. So sometimes it's important to move from, let's say, the Northeast, for me as a practitioner or our group, to make sure that we're giving our clients the best possible representation by understanding what's happening all over the United States, and let's say maybe even the entire world. There in Hawaii, there's a very large Japanese population. So there were a lot of international classes in regards to assets moving, let's say, from Japan to the United States, or the United States to Japan. Anyway, two biggest conferences. If anyone that is on this is a practitioner trying to learn information, they are two great conferences to go to. They give incredible presentations similar to the one I'm giving you now. It's a great thing to do as a practitioner, not for a layman necessarily, but you might want to ask your practitioner, do you go to some of these conferences? I don't know if you guys all know, but attorneys every year, in order to keep our license in the state that we are licensed in, we have to take continuing legal education classes. The continuing legal education class makes it so that we are up to date on the most current laws, regulations, statutes, court cases, so that we're giving you the best possible service. But remember, in the state we are licensed in, not all our attorneys are licensed in all states. Actually, I don't know any attorney who's licensed in all states, but maybe that's possible. So it's also really important to work with state-specific attorneys so that you can make sure that whatever's happening in that particular state is accounted for. So here we've got the probate code in California. It says, except as provided in this part, a will shall be a writing that satisfies the requirements of this section. It's got to be written by the testator. All right, we've got that. We've got a writing. It was written by Heche in the testator's name, and it has to be signed by the testator or in the testator's name by some other person in the testator's presence and by the testator's direction. Shoot. We had one of the two requirements. Oh no, this seems so simple. All it had to be was a writing and signed, right? Remember, even the signature. I had this case happen very recently. I just probated a will. The will was handwritten, which here in Pennsylvania and actually in California, they allow something called a holographic will. That's written in our own handwriting. Some states don't allow that. Pennsylvania and California do. But here in this case, there was a writing. At the bottom of the first page was the testator's signature. Okay, we've got a writing and we've got a signing. So by California law, I had a last will and testament. The problem with this was there was 9 more pages of information. That was just the very first page, and that's the only place they signed. So the answer is, at least here in Pennsylvania where we probated that will, the only thing that counts as a legally binding last will and testament is what is before that signature, which is very, very little. So it might even sound simple to say you just need a writing and it needs to be signed, but where does it need to be signed? It needs to be signed at the end, right? What happens if you make a change to that document? Where does that need to be signed? And the answer is, make sure you get good advice from an attorney. Don't just print out a document and make some written corrections on it, because one, they may not actually come to fruition, just like this, right? She didn't have a valid last will and testament, even though it looks like it's her intentions, which is something that I've talked about from the beginning, which is I want to make sure that we're adhering to the person who passed away's intentions, right? What did they want as their legacy? She obviously wanted James Tupper in charge of things, and she wanted things to go to her 2 children. Although I will say that email, if you noticed, was drafted in 2011, and she passed away in, what was it, 2023 or 2024? So there's a lot that could happen between one date and another. So who knows if that was even her intentions? But the answer is that it was not considered a last will and testament, right? So basically, here we've got the person's entitled here in Pennsylvania. Well, let's stop. Let's go back one more slide and see what happens. So now we know that it's not a valid last will and testament. It's an intestacy. The intestate law says everything goes equally to her children. That's great. That's kind of what she said in the last will and testament, but we need to get an administrator appointed. How do you get an administrator appointed? Pursuant to the state default law, or if you have a last will and testament, that last will and testament will say who's in charge. And again, this is another pitfall. Did she want her maybe drug-addled, very young, estranged son acting as the person who is completing all these legal requirements, tax requirements, dealing with this entire estate administration? Or did she want an adult like her ex-spouse or ex-boyfriend, James? The answer is the court awarded the administration to the 20-year-old son, Homer. And he is at the moment currently administering the estate. I'm not sure how much the estate is worth. There was a lot of debt, just like Lisa Marie, there was a lot of debt. But normally when we have famous clients, not only do they have revocable trusts, they may also have irrevocable trust and rights that pass down through that. We're going to see that when we get to James Earl Jones, that even if there are no assets, there might be continuing rights that pay out to individuals. So Homer is now technically in charge of that. I think they're still fighting through the court system, him and his brother's dad. And again, here, I'm not really sure if I like what the court has done. Now, what James had said to the court was, we've got a young, drug-addled, uh, uh, unstable, unemployed, somebody who doesn't have any ability to do this. This is a bad decision, court. And you know what the court had to say? The court had to say, this may be a bad decision. This may not be the right person to be acting for the benefit of himself and your son, because it was James Tupper's son, but it's the law. And unless you do something to change what the default law says it's the default law that controls. We never want the default law to control, whether we're in California or Pennsylvania or New Jersey or New York. We want it to be what we want it to be, and we want to understand that before we pass away, right? This probably was a bad decision. We probably don't want a 20-year-old dealing with this huge estate administration if all the things that have been alleged are true, right? Maybe he's not a drug addict. Maybe he's very financially sophisticated. I don't really know the answers to that, but I know as an attorney, I would probably not want my 20-year-old kid acting as my executor for my estate, right? That's a lot to deal with. And again, she passed away in a tragic circumstance, in a car crash. I think I did look up. There were no drugs or alcohol in her system. It was just a fluke car accident, and she burned to death. So not a fun way to pass. Maybe this is other advice too. Don't get weight loss surgery and be careful when you're driving a car. But that's just, I guess, commonsensical advice. But again, we've talked about now these two pitfalls. One, make sure you execute your documents correctly, and two, make sure you have those documents in place, right? And we only have a couple minutes left to talk about these last couple of cases. I'm going to sort of fly through some of these slides. Obviously, here in Pennsylvania, I just wanted to show you who would be acting, who has the ability to act under the intestate law if we don't have a last will and testament. Obviously, it says to who is entitled under the residuary estate, the surviving spouse, and then the intestate law, right? And so this is actually slightly different than what California said. California was surviving spouse, then children. So I wonder if this estate administration was here in Pennsylvania, would we have had a little bit more discretion to maybe appoint someone else, like a third-party representative? I'm not sure. You might also say, what does it matter who administers the estate? It matters a lot, especially when it comes to some of these rights I'm going to talk to you about that continue after death. There are lots of decisions that have to be made. Do we continue to invest assets that we're holding? How do we pay creditor claims? That's the next one we're going to talk about. Who actually gets paid? And then at the same time, remember, an executor administrator can take a fee for their services. So even if there's not a lot left, it still means that maybe they could get something. It also means that they get to be in charge of the decisions, which is something his not stepdad, but step ex-dad didn't want. He didn't want someone who might not be looking out for his son's best interests, as in the other son, to be looking out for his son's best interests. And the answer is, especially when it comes to blended families, get an estate plan in place so that that doesn't happen to you. So now we're going to talk about quickly here at the end, we're going to talk about O.J. Simpson, Orenthal James Simpson. We all know he was a famous football player, and he was married to Nicole Simpson. That was actually his second wife. His first wife, he had 3 children with, one of which, when she was 2, was walking around their homestead and out by the swimming pool, and actually fell in and drowned to death. So I didn't know that. So as we're talking about through this whole presentation, we're talking about death. We're talking about unexpected circumstances. We're talking about minor children, and here we've got a minor child's death. So anyway, he had 5 children with his second wife. He had 2 children. That's Nicole Simpson. So in total, he had 5 children. Only 4 were living when he passed away. He was not married at the time of his passing. Nicole Brown Simpson, we know, was killed. Criminally, OJ was found innocent, but civilly, he was found to have killed her and her friend Ron Goldman. So there was a lot of litigation, and there is a lot of money that OJ technically owed to the Goldman family. So here we've got pitfall number 3. We've got the wrong executor, maybe not. And his executor, what his executor said, and OJ did it right. He had a last will and testament with a revocable trust. The revocable trust had provisions for all of his children. None of his children were actually minors anymore. He didn't pass away till he was 76. He died of cancer. And all of his children were in their 30s or above. But still, he had good provisions in place. But he had an executor who was actually his attorney. You can do that. Just remember, attorneys charge for their services. So just think that through before you appoint, let's say, a lawyer or a law firm or an accountant or a third party of any sort. A third party is going to charge. Maybe a family member wouldn't charge. Of course, there's benefits and consequences to both. I have administered probably 1,000 estates in the amount of time that I've been practicing. So I bring a lot of wealth and wisdom to an estate administration. Maybe that's well worth the cost, right? Maybe your family member will forget to file a tax return and you'll end up owing interest and penalties 5 years from now. That turns into a problem. Again, a family member can be really valuable because they know your family members. They know that your kid's a loser and is going to ask for money from this trust on a constant basis, and you're going to need to be able to say no, and this is how I can help you, right? So there's benefits and consequences to both. So here we've got wrong executor. We have the executor saying, it's my hope that the Goldmans get 0, nothing, them specifically. And I will do everything in my capacity as the executor or personal representative to try and ensure that they get nothing. That's awful. Really, 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 really awful. First of all, it's illegal to say you're not going to pay a valid legal claim, right? But that's why I'm saying, was he the wrong executor or not? Because I have a lot of clients who reach out to me and say, maybe I could have a creditor in the offing. My husband and I own a business. Right now, our business is making money. What if tomorrow it's not making money and my husband's passed away and I have cancer? Maybe I want to make sure that I can shirk those creditors and give more money to my family members. So who knows? The answer is whatever we do, we want to make sure that we're doing it within the legal constraints of the state or the federal government, right? There's a lot of gray area in this world, and we get hired in order to work in that gray area, but we never want to do something illegal, right? And that's what this attorney said. Of course, he went back on what he said and said, really, it was just the attorneys for the Goldmans who were like, thank God he's dead, and now we're going to get paid. And he just said those attorneys were mean, and he didn't mean anything against the Goldmans or Ron's family. Remember, Nicole and Ron were both slaughtered to death. And he said he didn't have anything necessarily against him. But I want to talk to you about creditor claims. Remember, personal representative has to send notice to all known or reasonable ascertainable creditors. A creditor must file a creditor claim within a year of the decedent's death. Remember, this is Nevada law now because we've got a Nevada estate administration. And if the personal representative rejects the claim, the creditor can commence a lawsuit. If the creditor prevails and obtains a judgment, it's payable from the estate in the course of the administration. And a trust, which is revocable at the time of the decedent's death, is responsible if the estate is insolvent. So I get this question all the time. Can we create a revocable trust to avoid creditors? And the answer is, and you're seeing by Nevada law, and I'll say it again here in Pennsylvania as well, a revocable trust does not absolve any liability. The only thing a revocable trust does, well, it does a lot, and I've done some webinars on the differences between revocable and irrevocable trust, so go check those out. But basically, it avoids probate. It does not avoid liability. So here we see that this was bad faith. This maybe was fraud if the attorney doesn't pay it. But this is also Nevada law. And this is an order of claims. So let's say OJ's estate was insolvent. Who gets paid? There's an order in each state on who gets paid and what amount, right? So you're seeing these orders of payments. The last one that we're going to talk about, and I know it's the time has ended, but wait one more minute. It'll only take a second. James Earl Jones. If you wait long enough, I actually have a quick quiz, and the person who gets all the answers correct is going to get a prize from us here at Coinseglis. So hang on one more minute. James Earl Jones, we know he's the voice of Darth Vader, a very famous actor, and his pitfall was life planning. I'm not so sure that it wasn't, a pitfall. Sometimes we make investment decisions. I have clients that invest $1, and the next time I see them, it's worth $5. And I have clients who invest $1 and they are worth -$1 at the next moment. And some of it is just luck, or so it seems to me. But he decided to receive a one-time payment for services of the voiceover work on Star Wars of $7,000, where Obi-Wan Kenobi decided on a profit-sharing option that was eventually worth $10 million. So maybe a bad lifetime plan, but it's really important here to just remember not everybody has these intellectual property rights. These are things like copyrights or patents. They only last for a certain amount of time, like 70 years. Some are less than that. But when we have famous individuals, and I do have some, that it's important that we decide what are we doing with some of those rights after death, and then how does artificial intelligence factor into that? Because he assigned the right to his voice as Darth Vader for future materials, including the use of AI, before he passed away. So James Earl Jones, he passed away, I think, at the ripe age of 93. I think he was worth about 40 million. So when I say a pitfall, lifetime choices, he didn't get a lot from that voice, but he did okay for himself. He only had one child when he passed away who was an adult. But we want to talk about what's the individual's vision of how their reputation should be preserved, and if used, how is it going to be restricted? Does that restriction diminish the value? How can the ownership of the publicity rights be structured to integrate with the estate plan? And how does AI play a role in this as it's becoming more and more intricate into our lives? How does that factor into our estate plan? Maybe instead of giving away those rights during his lifetime, he should have assigned those rights to a trust, a continuing trust for his son's whole lifetime. Maybe we applied some credit to that trust and devalued maybe that value legally so that the growth of that asset is out from that 40% death tax. So there's lots of things that we could maybe do with things like intellectual property, things like business ownership, things that are hard to value. So Darth Vader, we just talked about that. How does that all play in? So remember, I'm going to ask you that trivia question right now. So remember the pitfalls. 1, make sure you execute your estate plan correctly. Pitfall 2, make sure you actually have an estate plan, including a last will and testament or revocable trust. 3, make sure you've got the right people in the right places that know what are the requirements that are required for the state that they live in the federal government. And 4, make sure that you look at a comprehensive plan. I have clients that call me and say, I don't need to tell you how much money I have or where I have it located. Just draft a will that says everything goes to my spouse and down to my kids. And the answer is no. We want to make sure that we look at everything that you have, how it's titled, and what you want to have happen so that that comprehensive estate plan can include all of these things and work as smoothly as possible with as many protections as humanly possible and the least amount of tax humanly possible. Okay, so without further ado, we're going to end this presentation. Thank you all so much for listening to me, watching me. This is how to guard your own legacy celebrity estate disputes and what they can teach us. Drop me a line sometime and say how I do. Certainly offer some criticism. Offer me any questions or other presentation material I can do. And without further ado, I'm going to ask you these questions. The first person who gets them all into that Q&A box is going to win a prize from Cohen Seglius. So here we go. What NFL team or teams did OJ play on? 2. Who was Lisa Marie Presley's second husband? And 3. James Earl Jones played who in The Lion King? So let's see if we get anybody get all of these correct. You're going to get a prize if you put it into the Q&A chat box. I will say, does anyone have any questions for me? Please type it into the chat box and I would be happy to answer it now or off screen later. Again, thanks for joining me. I try to do these sort of lunch and learns from time to time. And let's see, do we have any answers? Oh, it looks like the chat is disabled because we've got no answers. Oh, well, oh, there we go. We've got somebody. We've got somebody who answered. We're in good shape now. And it's right. We've got the Buffalo Bills. San Francisco 49ers is who UJ played on. Then Lisa Marie Presley's second husband is Michael Jackson. And third, James Earl Jones. Who did he play in The Lion King? Mufasa. We had some wrong answers. Nicolas Cage was the third spouse, not the second spouse. So awesome. We will send out that gift to the person who answered all of those questions correctly. Again, thank you so much for joining this Lunch and Learn. I hope you got some really good information. These things are really important. I'm trying to make it as fun as humanly possible, but hopefully you get some really good nuggets of gold. We will send this recording out to all of you. It is on YouTube. It is also on our website. And otherwise, just thank you so much for joining me and have a wonderful rest of your day. Thanks, everyone. Again, this is Whitney O'Reilly signing off.